The courtroom was silent when Judge Harold Whitman lifted his gavel for the final time that day. The defendant, a quiet young man named Daniel Moore, stood frozen as the sentence was read aloud. 25 years. No parole for the first 15. Daniel didn't cry. The case had been ugly. A late-night robbery. A convenience store owner beaten nearly to death. A single eyewitness who swore Daniel was the attacker. The prosecutor had built the story carefully, brick by brick, until it felt solid. There had been a moment, just before sentencing, when Daniel leaned toward the microphone. "I didn't do this," he said softly. "I swear on my mother's grave." Whitman had raised his hand and reminded Daniel that the time for testimony had passed. Whitman took a sip of bourbon and told himself he had heard those words hundreds of times. Everyone said they were innocent. It meant nothing. 2 weeks later, a letter arrived in chambers. It was handwritten. The paper folded carefully. "Your Honor, I know you probably won't read this, but I had to try. My name is Daniel Moore. I was sentenced in your court. I am innocent. I didn't rob that store. I didn't hurt that man. I was at work that night, but my boss was scared and wouldn't testify. I don't have money for a good lawyer. I don't have anyone else to ask. I know the law says the case is over. I just want you to know the truth." For months, life went on. New cases filled the docket. New defendants stood where Daniel once had. The letter stayed in the drawer, unopened again, until the night of the robbery victim's death. The store owner, Mr. Kaplan, had never fully recovered. Complications from his injuries took his life 8 months after the trial. The news article was brief, almost forgettable, but one line caught Whitman's eye. Police continue to investigate new leads related to the original assault. He told himself it was none of his business. Appeals existed for a reason. If new evidence emerged, the proper channels would handle it. Yet that evening, he unlocked the drawer and reread Daniel's letter. The next day, Whitman did something he had never done before. He asked his clerk to quietly pull the case file again. He read the transcripts carefully, line by line. The eyewitness testimony was confident, almost too confident. The man had been across the street, in poor lighting, glimpsed the attacker for less than 10 seconds. The security footage was worse than he remembered. The image was blurred, the face completely obscured. It could have been anyone of similar build. The alibi had been weakly presented. A time card from a warehouse. A supervisor who suddenly became unavailable. Whitman leaned back in his chair, a faint unease settling in. Had he missed something? He reached out discreetly to an old colleague in the public defender's office, asking general questions about the defense attorney who had handled Daniel's case. The answer came back quickly. Overworked, inexperienced, juggling 50 cases at once. Whitman felt a slow, unwelcome realization forming. Weeks passed, then months. More news articles surfaced. Another man arrested for a string of late-night robberies, all within the same neighborhood. Same method, same brutality. One detail stood out. The suspect was left-handed. The store owner had told police his attacker struck him with the left hand. Daniel Moore was right-handed. Whitman's heart pounded as he read the report. He sat alone in chambers long after the courthouse emptied, staring at the wall as the weight of possibility pressed down on him. If Daniel was innocent, judges were trained to respect finality. The law needed closure. But what if finality had come at the cost of truth? Whitman began to lose sleep. He dreamed of gavels cracking, of courtrooms filling with faces that stared at him silently, accusingly. Daniel's face was always among them. One evening, unable to bear it, he requested a meeting with the prosecutor who had handled the case. She listened patiently as he raised his concerns, arms crossed tightly. "With respect, Your Honor," she said. The jury weighed the evidence. The conviction was sound. "What about the left-handed detail?" Whitman asked. She hesitated, just for a second. It wasn't definitive. Her words were sharp, defensive. Whitman nodded. He knew what he should do and what it would cost. Judges who openly questioned their own rulings risked reputations built over decades. They invited criticism, even disciplinary review. The legal community valued confidence, not second-guessing. Still, the law also valued justice. Whitman drafted a memo requesting a formal review of Daniel Moore's conviction based on newly surfaced evidence. He reread it a dozen times before sending it. The response was swift and discouraging. Whitman slammed his desk in frustration, a rare crack in his controlled exterior. Against advice, Whitman requested to visit the state prison under the guise of a routine inspection. It was legal, uncommon but allowed. When Daniel was brought into the small interview room, he looked thinner, older. His eyes widened when he saw who was waiting. "Your Honor," he said, voice barely above a whisper. Whitman swallowed. "Mr. Moore," he said carefully, "I can't discuss your case directly, but I need to ask you something." Daniel nodded eagerly. "Where were you the night of the robbery?" "At work," Daniel said instantly. "Warehouse on Jefferson. I clocked in at 9, clocked out at 5. Why didn't your supervisor testify?" Daniel's jaw tightened. "He said the company didn't want trouble. Said I should just handle it." Whitman closed his eyes briefly. "Have you ever met the man who robbed that store?" "No," Daniel said, tears forming. "I swear, I've been paying for something I didn't do." For the first time in his career, Judge Harold Whitman apologized to a defendant. "I'm sorry," he said quietly. The word felt heavy, inadequate. Whitman left the prison knowing he could never unlearn what he now believed. He went public. In a rare and shocking move, Whitman issued a written statement expressing serious doubts about a conviction he had presided over, urging appellate courts to expedite review in the interest of justice. The backlash was immediate. Fellow judges distanced themselves. But something else happened too. Journalists began digging. They uncovered the warehouse time cards. The supervisor, now working elsewhere, admitted that Daniel had been present that night. Security footage from a nearby loading dock showed Daniel entering the building minutes before the robbery occurred miles away. The new suspect confessed to multiple assaults, including the convenience store robbery. It took nearly a year, but the conviction was finally overturned. Daniel Moore was exonerated. Daniel had lost 6 years of his life. There was no ruling that could give that back. At a quiet press conference, Daniel was asked how he felt about the judge who had sentenced him. He paused. "I think he tried to do the right thing," Daniel said. "I just wish it hadn't taken so long." Those words followed Whitman into retirement. He stepped down the following year, citing health reasons. In truth, he was tired in a way sleep could not fix. On his last day, he cleared his chambers slowly. In the bottom drawer of his desk, he found Daniel's original letter. He read it one final time, then folded it carefully and placed it in his pocket. Too late, he thought, not just for Daniel, but for the version of himself who had believed that justice was always as simple as a verdict and a gavel. Subscribe to watch more.